Hello and welcome to Reading the Receipts, the sometimes weekly update of the Blake Lively versus Wayfarer court case, providing deeply uneducated analysis on all of the court filings hitting the docket. I have missed you guys. I'm sorry that we took a break last week, and of course, predictably, when I do take a break, that is when we have an absolutely packed docket. So tonight we're going to be doing a double stream, which means that we're going to have to speed run through the first part in order to make sure that we're still on time for the second part. So in part one, we're going to talk about all of the motions to dismiss and sort of talk about the cleanup that's happened since the motions to dismiss Baldoni's case. Sorry, the motions to compel is what we're going to talk about. And then in part two, we'll talk about specifically, I want to talk about some Jed Wallace things, the tag employees, because we've had some more information and revelations about the smear campaign and possibly Jed Wallace perjuring himself, maybe? We're going to take a look at that later. All right, so we're going to get into it because, like I say, we have to speed run today's first part. So join with me. If I am talking too fast, though, chat, please let me know. But as always, we're going to look at some legal documents. I am not a lawyer, certainly not your lawyer, and none of this is legal advice. All of the allegations we're going to cover tonight are just that. They're allegations and they have not been proven in court. Nothing we're talking about should be taken as a point of fact. This is all just opinion provided for entertainment purposes only. Awesome. Well, hello chat. Hey Marcy Jenks. Hey Gina. Hey, I think, do you? Appreciate you in here. You say you made the live finally. Well, we're glad to have you. Junk Farm, good to see you. And my lady, good to see you too. All right. So, like I say, we got a lot to get through. So, brace yourselves, chat. We'll get through it. We'll get through it together. All right, so let's start out with most of what we're going to be talking about is the cleanup that has happened since Baldoni's entire case has been dismissed. Now, the deadline for him to amend his final two complaints that are still surviving is tomorrow, I believe. So we might see it be revived on the two contract claims, but in order to do so, he will have to provide the details of those contracts. I'm going to put it out on stream. I don't think a second amended complaint is going to happen, but we'll see, right? Maybe we come back next week and you can prove me all wrong and we see a brand new complaint with those contracts. We'll see. So let's go through the cleanup. Hi, Sophia. Good to see you. So the first piece is that Brett McDowell's motion to intervene got struck down and denied on the basis of having no interest in the case. And I've talked about McDowell before. I'm not really going to talk about him. Again, I will refer you to X if you want to go learn more about him. He then responded by filing a motion to recuse Judge Lyman from the case, citing all of the Reddit conspiracy theories about his conflict of interest and all the rest of it. We will see if that is any more effective than anything else he's filed on the docket. I doubt it, but we shall see. After that, let's see, what else did we get this week, last week? 3:38, Sarah Nathan, the new journalist for New York Post and Page 6, who's featured heavily in the complaints, filed for a withdrawal of her motion to quash her subpoena, given that now that Sloan is out of the case, that is no longer needed. I don't know if we'll see a new one from Lively. I would imagine so. So we'll see if that comes back up. But with Baldoni's case being dismissed and Sloan being no part of it, there's no need for any of this. James Vituska, another reporter that is involved in this case, filed for a change of attorney. James, if you remember, is the Daily Mail reporter who, again, is involved in all of the screenshots, who had handed all of his conversations over to Wayfarer and they used it without his permission in the complaint. Well, he's changed counsel now to Garagos and Garagos. This is bad news. Mark J. Garagos is a good friend of Freedman, Wayfarer's lawyer. They've worked together on a lot of cases. I suspect this means that he is no longer going to hand over his communications with Bryan Freedman anymore, given that he's now being represented by Bryan Freedman's good friend. I think they will be fighting tooth and nail to keep Vituska's conversations out of evidence and out of discovery, but we'll see. So I think this is not good news for Lively, given that Vituska was complying, and I think the moment that he filed to the court that, hey, I'm going to comply and hand over my documents, he got a call from the other law firm saying, we'd like to represent you instead. Junk Bomb says changing attorneys is interesting. Always interesting, but it's particularly these attorneys is what makes this I think, damaging. The other thing that happened is Lively withdrew her claims for emotional distress. She had to confirm with the court that in doing so, she still would be able to claim garden variety emotional distress as part of her claims in her lawsuit. And the judge said, yes, that would be fine. And so she has withdrawn her 10th and 11th cause of action. Remember, her case, her complaint, has 15 causes of action. Only now it has 13 causes against Wayfarer. So I do say this is a win, right? It's not a big deal. I think most people thought that they would drop off anyway because intentional infliction of emotional distress is so hard to prove. It also opens you up for a lot of cross-examination and all the rest of the stuff of like bringing in, therapists to, psychologists to analyze your mental state and all of your health records. So it was probably always going to drop, but it's still a win, right? 13 is better than 15 for Wayfarer, so good win for them. But like I say, she will be pursuing garden variety emotional distress as part of her damages. Okay. Ryan Reynolds and Blake Lively also added in their support for their Rule 11 sanctions against the Wayfarer parties, or some of the Wayfarer parties. So that completes their pleading for that. They're very similar. They're not quite identical. Ryan's is a little shorter, so I'm just going to go through Lively's just for time. But they say a lot of the things that we've already talked about when I read through Wayfarer's objection to this. They point out, look, they were not able to detail the extortionate threats or what the extortionate threats were to Sarowitz, Nabel, Athorn, or the It Ends With Us movie. So why were they ever plaintiffs in that case? She goes on to say, they made this whole argument of, well, you're confusing sanctions with a motion to dismiss. And just because our pleading is bad, you should be using a motion to dismiss to argue it, not Rule 11 sanctions. She points out that, look, I'm not attempting to do that. I'd already filed my motion to dismiss, and it got dismissed earlier today, kind of rubbing in that, hey, your claims were kicked out of court. They're saying, no, look, your claims are so baseless and brought with such an improper purpose that they're sanctionable, arguing that they are confusing poorly pled claims from ones that are sanctionable. Unsuccessful claims with sanctionable claims is what she's saying in here. They go on to say, second, they argued that she would have to wait for her motion to dismiss, but of course now she says, well, the court has granted that motion to dismiss, so that argument has gone entirely. And then third, they argue that it's premature because discovery is still in their infancy, and she points out that hardly at all is it in its infancy. We're about to close substantial completion of document production next Tuesday. Not the coming Tuesday, but a week on Tuesday. So no, we're very close to it. But it doesn't allow you to file frivolous claims and then hope discovery renders them non-frivolous, which is what we talked about at the beginning, right? Like, you have to have sufficient factual basis at the time the claims are asserted. You can't go dig for evidence afterwards to then justify why you brought those claims in the first place. They haven't even articulated what potential discovery could possibly be relevant to support their claims, and especially when we're talking about threats against It Ends With Us movie, like, that's not even any part of their pleading or their claims. So there's never going to be any discovery that shows that. And I think, yeah, so that's it. So then basically it goes on to say they then argued themselves for sanctions, and no, they're not entitled to that. So again, I don't know whether we'll see sanctions, but it doesn't feel like Wayfarer really put up a good fight against it in their motion, so we'll see. The next piece we're going to talk about is the various motions to compel. There's a bunch of them on the docket. It is very confusing, so I have very kindly done a graphic because if there's one thing I love, it's graphics to help us all out. So there's 5 motions to compel that we're going to talk about. It's a little confusing because we're going to be talking about third parties and third party investigation and like which, what, blah, blah. So I'm going to break it down. We're going to go pretty slow, but there's 5, right? The first is against the Wayfarer third parties, which, as you can see, this over here, we're going to talk about in a second. We're going to talk about the third-party investigation, which, if you remember, was started in January. We're going to talk about a motion to compel Wayfarer to produce information about content creators that they had talked to. But the surprise was that Liner, Freedman, Tadelman, and Cooley themselves, the law firm, were served a motion to compel. Now, I'm going to give credit to More with MJ, MJ Morley, who is on Threads. I'm fairly sure most of my chat already follows MJ, but if you do not, please do. MJ had found this on the docket, so all credit to MJ for her continued dedicated sleuthing to finding this stuff. But yes, Lively is compelling the law firm themselves, arguing that they are a party to the smear campaign ongoing. So, and then finally, we'll talk about the big topic, which is Taylor Swift. So this is why we're going to kind of burn through quite a bit, because we've got a lot to talk about with Taylor Swift. So, Wayfarer third parties. Lively had argued that she needed material and information from these 9 Wayfarer third parties. One of them isn't really a Wayfarer third party, and that's Jennifer Benson over here on the right-hand side. She is an integrative holistic health coach. This is the health coach that Baldoni reached out to about, I think, like probiotics or something for Lively when she wasn't feeling well and breastfeeding, and so Lively alleges that it was a bait and switch and she was actually trying to help her to lose weight, and this was another way in which Baldoni was negging her about her weight and trying to get her to lose weight. So they've asked for these people to produce information. Now, they're pretty relevant. Now, I didn't go through the names before, but I went through them today and realized, actually, these are all incredibly relevant. Tara Hanks is president of Wayfair and featured in a number of the text messages that we've seen in the complaints. Ashmi Elizabeth Dang is VP head of marketing and communications. Also in a bunch of the communications, and in particular involved in the communications in May, before they hire the crisis PR firm, where Jennifer Abel talked about she's going to work with Ashmi Elizabeth Dang to come up with a plan in case Blake Lively also unfollows. This is when they find out that Ryan Reynolds has unfollowed and blocked Baldoni and Wayfarer, and so they argue that, oh, the marketing team need to come up with a plan in case she does the same. Ashmi Elizabeth Dang was part and involved in that, allegedly. Mitz Toskovich, also called Milika, VP of Operations, is mentioned quite a few times in the communications. And then the other names are, I'm going to assume this is Jerice, but it could be Jerry S. So either way, I apologize if I get those wrong, but Jerice Blackman, Shekinah Reese, AJ Marbury, and Dion Suleiman were all executive assistants. Jerice doesn't really kind of tell us who. He's just an executive assistant at Wayfarer. I don't know who he was executive assistant to, or if it was just general. But Shekinah Reese is credited on It Ends With Us as being the assistant to Jamie Heath. AJ Marbury and Dion Suleiman are credited as being the assistants for Mr. Baldoni. So it's very clear that they have relevant information. If they were on set and the assistants to 2 of the men involved, it's very clear that they would have information and communications, probably in conversations with them, about the events on set, about Lively's complaints. So yeah, it seems relevant. Anyway, Jerice is also mentioned way back in February. If you'll remember, Lively originally subpoenaed T-Mobile for call logs and data about communications. Jerice was one of the names mentioned on that original T-Mobile subpoena. So definitely very relevant, definitely people that Lively is interested in talking to. So Judge Lyman put an order onto the docket asking Lively to respond to say, hey, at any point has Wayfarer's response on this giving you the information you need? Can they produce? What happened was Lively had asked for this information, I think back in March or February. They pushed back and wanted deadlines in April, which they were given. They missed their April deadlines, and which is why Lively had filed her motion to compel, saying, hey, they've missed their April deadlines. We need help in getting them to give over the information. So again, now it comes to June, and Judge Lyman is saying, hey, has this been resolved? Lively says no. The issues in her motion to compel remain outstanding. She served subpoenas on them in early March, agreed to the extension of those deadlines into April, but so far, none of the Wayfarer third parties, and if you remember, Wayfarer had stepped in the email chain to say, hey, we'll take responsibility for collecting the material from them. So none of the Wayfarer third parties, all of whom are represented by Wayfarer Studios, have produced a single document from his or her individual possession, custody, or control. Remember, they couldn't name if they had personal devices, what devices were being collected, what information was being collected. Like, they provided no details about any of it. Yesterday, counsel for Wayfarer third parties informed Lively that they would need an extra deadline and would be produced no later than July 1st, which coincidentally is the deadline, as she says here, which is the deadline for substantial completion of the documents in production. But the Wayfarer parties have already agreed to extend the subpoena compliance date months ago, yet have continued to delay at every step. Given how they have treated these prior agreed upon deadlines, they have no assurance that they will adhere to the last extension, and discovery is set to close in just over 2 months. So this is why she's asking for the court's help that, hey, we definitely need them to come in and help with that compel. So then Wayfarer responded, Gina, really appreciate the donation. Thank you so much for the super thanks. This will be continuing to pay for my my Pacer addiction right now. I think I've talked about this with some of my mutual friends, that I am now giving money to my wife because I'm using her credit card to pay for Pacer. So I have a pocket money and an allowance for Pacer. So I will be putting your very generous donation towards my Pacer allowance in providing more of these documentations as they get released. So thank you very much. Appreciate it, Gina. So Wayfarer came back and said, do you know the problem is? Discovery's hard, guys. Discovery's hard. They said, the subpoenas seek a broad range of documents and communications from professional and personal sources. Complying with these demands requires a thorough and time-consuming collection and review process across 9 custodians. 9 people, it's just too much. Bear in mind that they are handling 9 people on their side, right? You've got Baldoni, Heath, Sarowitz, Abel, Nathan, Tag, RWA, Wayfarer. It ends with this movie. And they're complaining, they're saying, oh, 9 is too many. They are handling many, many more people, and perhaps, if it is such a burden, maybe not have them all consolidated under one legal representation. The Wayfarer parties then have said that they've not evaded their obligations, but much as they did back in May, are saying that they are actively working to complete their production. Today, they say that they've made multiple productions, including email and professional materials. A substantial volume of the data has been collected from servers, databases, and other repositories. It's currently being reviewed and will be produced on a rolling basis that they expect to complete by July 1st. So they're saying, look, we're almost ready to start handing over this information, and we will be done by July 1st. We expect to complete production by June 27th, and at any event, no later than the deadline. Notwithstanding the substantial efforts, they say, Lively's trying to seek code invention, and it's totally unnecessary. They also point out in their footnote here that Lively has indicated her intent to pursue enforcement in the Central District of California and Northern District of Georgia, which is where the individuals live, and so she's also trying to pursue this in local district court, saying that, hey, that's where she's trying to put it in. And they're saying that's where it should be, and her trying to do this in this court is duplicative, and she shouldn't have been doing it in Southern District of New York. Well, the judge came back and gave his decision and basically agreed with Wayfarer. He basically says that Wayfarer say they're still collecting documents and that they would produce them, and that we'd like jurisdiction to compel compliance, and that those subpoenas should be delivered to California, except for Dion Suleiman's, which should be in Georgia. And so basically says Lively's motion is properly brought in those districts and denies it. So that was a little bit of a blow, because obviously if she hasn't already brought them in there, there's a time limit of 2 months to close out discovery. So the clock is ticking in order to get these productions. So again, another bit of a win for Wayfarer, that they don't have to do it, but makes the case a lot harder because there is less evidence to go around on both sides. All right, see, look at that, moving along. Move on to the third-party investigation, right? So little bit of difference. There we go, boom, move the arrow along. Make sure I keep up with the arrow chat and shout me if I don't. My lady says, I thought you said you'd work 24 hours around the clock, referring to back in February, the original first hearing that we had. Judge Lyman was worried about Freedman representing so many people and being able to produce and provide discovery. And he said, we won't be holding anything back. We will work 24/7 if we have to make sure that we're on time. Now, of course, he's saying that discovery for 9 people is really hard and burdensome. So a little frustrating to hear that. All right, so before the motion to dismiss, Lively had asked permission to file a letter about the third-party investigation. So if you remember, in January, Wayfair had hired a third party to investigate her claims of sexual harassment, which they say was born out of, oh, we didn't know about them before, so we are going to, in an act of good faith, now that she's revealed them in the CRD complaint, which is our first knowledge of these complaints, going to do a thorough investigation. Lively's argued that they are actively interviewing witnesses, going around talking to people, that they have Wayfair's counsel present in those interviews, potentially to intimidate or bias those interviews, and that they're collecting all of this material which they are not sharing with Lively, meaning that these people who are being interviewed are not doing so under oath, and then when they are interviewed under oath in court may say something different, and Lively cannot prepare for that because they are keeping all of that information to themselves. So she brought up this and saying that they had brought up, they had given a privilege log showing what information they had, that it was insufficient, and that they are not turning over any of the information. Lyman came back and gave basically Wayfair an order to respond, saying that Wayfair say that they cannot produce any documents because the investigation hasn't given them any of the documentations yet. However, any documents in possession of a party or former counsel are deemed to be within their control and custody. So if they are acting as counsel on behalf of Wayfair in this investigation, then they are classed as being controlled by Wayfair, and Wayfair have access to the documents. In addition, he adds that of all the documents and communications concerning the investigation, clearly includes the documents already possessed by Wayfair, such as the engagement letter with the investigators and their correspondence. So he ordered Wayfair to respond by 5 p.m. on June 12th, telling me why you can't produce any of those documents. So Wayfair did exactly that. Wayfair's response was to basically say, look, argue the same thing that they've talked about before. It's attorney-client privilege, work product doctrine, and that they were undertaken by counsel to render legal advice and are protected from disclosures by both attorney-client privilege and work product doctrine. Now, this contradicts what they had said earlier. Originally, the investigation had said that they were not providing legal advice, that they were not adversarial, and they were conducting a neutral third-party investigation. Wayfair now have turned around and said, no, they are part of an investigation to give us legal advice and in order for us to plan out our legal strategy. They bring up the privilege log and say that Lively erroneously contends that it undermines their position. But it was an earlier version, and now they provide the real log, which actually has the dates on it, which includes January to ongoing, and does show that, yes, documents were provided to Wayfarer, but they're arguing they are all privileged. Lyman came back with his decision, and again, denied the motion to compel. Let's celebrate there for, yes, okay. On about December, he talks about it and says, the communications with counsel are for the purpose of obtaining legal assistance or documents prepared by counsel in participation of litigation, so they are privileged. She doesn't get them, is what he says. However, what he does kind of concede is that Wayfarer had argued in it that this is not part of their legal obligation to investigate the sexual harassment claims as raised by Lively in her CRD. Wayfarer had said, no, originally, no, it's nothing to do with that. We're doing a separate investigation, saying there that Wayfarer had stated that the 13th affirmative defense had nothing to do with the investigation underway. Wayfarer will be precluded from relying on the current investigation in support of that affirmative defense. So any legal obligation that Wayfarer had in terms of investigating claims of sexual harassment, Lyman is basically saying this third-party investigation that now started in January cannot be used to support that, hey, we fulfilled our duty to investigate these claims. It's a small win, but it's not a big one. The fact is that Wayfarer still continue to interview witnesses ahead of the trial and be able to prepare these notes without having to hand over anything to Lively. That's a big deal. I don't know why this went this way. I don't fully understand. But it does feel like a huge disadvantage that Lively's legal team will be at not having this information. How is that not witness tampering, says the junk farm. I don't know. Our scientist, it is good to see you. I hope the coffee is good. Are we ground? Are we drip coffee, filter coffee? Like, you let me know. I'm a big ground coffee here, big, drip coffee. So yeah, this is another loss on the motions to compel, unfortunately. So let's move on to content creators. One of the other motions to compel that Lively was working on was compelling from Wayfarer a list of reporters that they had talked to. But in particular, we got information about possibly the smear campaign that Wayfarer were using. Lively had asked Wayfarer, or Tag specifically, for information about email accounts that they were using them as, I called on threads on Twitter, a dead drop. Now, a lot of people were asking me, I was like, well, what's a dead drop? So the idea being, let's say that I want you to be involved in this smear campaign. If I start texting, let's say, Heidi the sausage, because Heidi just walked in. Heidi says dirty instant. I tell you what, it's convenient, but yes. Let's say that I want Heidi the sausage to be part of my smear campaign. I can message Heidi and say, hey, I want you to make this content. I want you to do these things. But there's going to be a record of those communications. Now, we might use something like Signal in order to hide those communications. But even Signal, those communications can be subpoenaed and traced, or at least we can see information even if we don't get the actual messages. We can see there was contact, which is suggestive in itself. So what if you want to do a completely untraceable smear campaign? Well, what I can do, and this is what Lively is alleging that Tag have done, is I can create a brand new email account. I can create it and I can give it a username and password. I can then share that username and password with Heidi the sausage, or I can use a username and password that Heidi the sausage would already know without having to share it. I create that email account, I log into the email account, and I can use the draft folder to create a new email with all of the instructions in it. I can attach files to it. I can use it as a dumping ground to put all this information and requests in, and then I log out. Heidi comes back later, logs in, and then executes all of these commands because Heidi loves to do these sorts of things, I guess. I don't know. I'm sorry, Heidi, for picking on you. But the idea being then there is no direct contact between us. You can't subpoena our messages or our communications because it wouldn't show anything. That's what Lively's alleging that Tag had done. And it was asking for all of the email accounts that they had provided access to third parties. Now, in response, Wayfarer had come back and said, well, you've said, you want access. We don't understand what access means. They don't fail to adequately define what access is. So this is why we can't comply. The Lively parties have been unable to clearly articulate what they're seeking, although they did give two examples by providing login credentials was their suggestion. The catch-all language created ambiguity. I don't know what's ambiguous about who did you provide login details to an email account to. It seems fairly clear. Without citing any evidence or even specifying the factual basis for their allegation, the Lively parties allege that they believe that the Wayfarer parties have engaged in covert tactics to communicate with third parties in a manner to avoid leaving a paper trail, such as placing information in a draft folder or other email repository, and then provide third parties with viewing access to the folder or email, enabling the third party to view the information without leaving a digital trace. Now, in Lively's request of a motion to compel, she had said that the Wayfarer parties had never denied this in their discussion in email over what those terms would mean. So Wayfarer come out and say categorically, we have never engaged in such alleged clandestine communications. She also goes on to say that, they have requested information with media outlets with whom the Wayfarer parties have communicated. They wanted to limit this to only like certain topics and certain pieces about this. The lively parties have improperly refused to limit the scope of this interrogatory. You ready for that, Jim? I've been practicing. To communications only concerning the claims and defenses in this action. They wanted to really just narrow it about only to reporters or journalists that we've talked to, just specifically about the claims in this lawsuit. Lively wanted it much broader than that, about anything about like the film or the complaint or about her generally. The lively parties do not explain how the identities of the media outlets through whom some of the Wayfarer parties promoted the film or communications are relevant to Lively's claims or the Wayfarer parties' defenses. And it seems pretty obvious that if you're alleging a smear campaign where they talk to a bunch of reporters, the list of the bunch of reporters you talk to would be exceedingly relevant. Who is Bryan Freedman? I don't recall. Oh, I forgot that piece. If one of you in chat can tell me which of the subpoenas that is in so that I can bring it up. That would be amazing. I think it's in these, isn't it? I think it's in these. All right, we're going to quickly go on a run for that in a second because I think we're doing good on time. Nevertheless, they decided they would respond, but only from June 15th through to December, which is the date that she filed the CRD complaint. And you'll see this a lot as we talk through tonight and the second part. They really, really, really want this deadline of just up until the CRD complaint. They do not want to provide any information after the CRD complaint. The lively parties are having sought to expand it to the present because they allege that the smear campaign is still going. And then we also talked about content creators. Wayfarer had tried to limit this to only content creators with 10,000 followers, only content creators who produced original content, only content creators who were monetized, and only content creators who talk on a topic relevant to the claims in this discussion. So it would basically eliminate a lot of content creators. They talk here about they tried to narrow it to those creators who monetize their content or at least have 10,000 followers or subscribers, which is a widely recognized benchmark where online users unlock monetization features and begin to attract brand interest. That is a fair point, but when you go back and read Lively's complaint, a lot of the accounts that got boosted, or that she claims got boosted, are accounts that are much smaller than this. They suddenly have a breakout video that gets millions of views, even though they have a much smaller audience. Now, to be clear, that does happen. Talking about myself and my journey as a content creator, most of like my growth happens when I put a video out that gets a lot of engagement, more than my usual videos, and that then brings in more people, right? So it's not out of the realm of reach that somebody without 10,000 followers gets a 2, 3, 4, 5 million view video, right? It does happen if you produce something that is really interesting and really engaging. It definitely is suspect when you see so many of them, especially on this topic, having these big hits like this. There's a couple of creators, I'm not going to mention them by name, but when you go through Lively's complaint, you go back and look, they have had no engagement on any of their videos. But the 1 or 2 videos that they make that are about Blake Lively, specifically around this time, have like 2-3 million views. It's not indicative of anything. It doesn't suggest anything. It is just one of those little data points that's like, interesting. And it would be worth checking, I think, on Lively's side. The Lively parties rejected the proposal to limit them. And so they also proposed to limit the communications to only concerning the subject matter of this litigation. So they're saying that they should be denied essentially because it's too broad and too much information. Jenny Richardson says, Candace Owens and Perez Hilton. Oh, we will get to those shortly. I think DU says, I have about 30 minutes till I arrive at work. Oh, well, I hope you have a good day for work. I appreciate you tuning in. I hope that you are not driving while you're listening to this, or at least if you are, you're not watching and just listening. Definitely be safe. Marcy Jinx said, trying to narrow it down to nobody he used. Yeah, and there's obviously that was Lively's kind of argument, is to come back and say, well, you know, if you do that, it's live narrowed down to nobody interested. All right, so quickly, I do want to see if I can go find that I was talking about. So what was that? This is 311. All right, so let's see if we can quickly find these subpoenas. I think this was 311. I don't remember what Lively's original one was, so we'll see. You get to see how the sausage is made a little bit here, right? So this is response to 295. I think the ones for 295 all got opened up, didn't they? They did indeed. All right. To give you an idea of how ridiculous these subpoenas are, or the responses to these subpoenas are, this is Justin Baldoni's response to Ryan Reynolds' first set of interrogatories. Nailed it. See, the Junk Farm's going to be so proud of me now. Like, the journey of this live stream. So this is their response. If you want to see how ridiculous these are, I'm fairly sure. Come on. Am I missing it now? There it is. Responding party objects to propounding party's definition of Bryan Freedman on the grounds that it is vague, ambiguous, overbroad, and unduly burdensome. Responding party will construe the term Bryan Freedman to mean Bryan Freedman. What are we doing here? What nonsense is this? They're arguing that, oh, well, Bryan Freedman could also mean any of his past or present members, officers, employees, partners, corporate parents, subsidiaries, or affiliates, regardless of their relationship to the allegation. Like, yeah, no, when we say Bryan Freedman, we mean Bryan Freedman. It's, I get it. Part of it is like legal boilerplate and, you know, the lawyers doing their jobs. This is frustrating and would cause me to probably lose my job as a lawyer, because I would be sending out all manner of expletives in response of like, what do you mean? We all know what we're talking about. Bryan Freedman is, yeah, Bryan Freedman will Bryan Freedman till the day that Bryan Freedman dies. We talked about that last week. All right, so yeah, so this was incredibly frustrating. So where are we at now? I'm trying to go back to my notes so I can make sure I see the right number. Lively's response was, am I right? Compel investigation? Yeah, okay. So this was 311. Okay. The judge asked them to respond, I think, and see if that, again, you know, solved the issue. And Lively responded to say no. Advised the court as to whether the Wayfarers' supplemental interrogatory responses, oh, that was it. They were going to answer with additional responses by, I believe, June 13th. They said that they were going to provide additional answers. So June 16th rolls around. Lyman asks Lively to report, hey, did Wayfarer respond, and does it actually give you the answers you were looking for? She said no. On June 13th, they did provide supplemental responses, but it didn't resolve the motion. Jennifer Abel and Melissa Nathan failed to serve any supplemental responses to any of the interrogatories. As such, the responses of Abel and Nathan, whose texts are key evidence supporting the allegations, are critical evidence in the case. Seems fairly obvious. Now, part of the problem is that Lively asked for a bunch of things and Reynolds asked for a bunch of things. They did not ask for the same things. And of course, Reynolds gets dismissed from the case. And so part of what we're dealing and contending with here is Wayfarers are being selective in what they're responding to, because they're only responding to Lively's requests, not to Reynolds, because he's now been dismissed. And so part of this conversation is about this. And you'll see in here, she starts to talk about what Reynolds had asked for and what Lively had asked for. In terms of the email accounts, the motion is seeking this court to compel each Wayfarer defendant to identify all email accounts that were made accessible to third parties. In their opposition, the Wayfarer parties agreed to respond only as to tag and only to a specific type of access, i.e. providing third parties with login credentials. The Wayfarer parties then said that they never engaged in the alleged clandestine communications. They also added a one-word response to say, no, they didn't provide any of them. Only tag supplemented its response, and they did not identify any email accounts. Tag's response does not clarify whether it includes all email accounts as to which it provided any form of access to the third parties, or if it includes only email accounts in which it provided login credentials. Based on the opposition, right, and their kind of argument that access is loosey-goosey and we don't know what that means, they assume that they mean Wayfarers put their interpretation, and that would not be sufficient, right? We don't want to know just the ones you provided login credentials to, but the accounts that you provided any sort of access to. The other Wayfarer parties all failed to answer. They claim that Mr. Reynolds is no longer in this action because he was the one who asked for those things to those parties other than Tag. And Lively tries to argue that, well, you know, they're saying that they're going to file an amended complaint on the 23rd and Reynolds would still be back in, so therefore we should get full answers to this interrogatory because Reynolds is going to probably be back in if they file an amended complaint on Monday. In terms of reporters, she also says that that's unresolved. Most notably, as stated above, the two individuals charged with communicating with reporters, Nabel and Nathan, failed to supplement this request at all. While the remaining Wayfarer parties did supplement their responses, they unilaterally narrowed the time frame to that June 15th to December 21st window. As Lively alleges the Wayfarer party's retaliatory smear campaign is ongoing, such narrowing is inappropriate for the reasons set forth in the motion. So she's asking for further because, you know, part of it is she's suing the Wayfarer parties for defamation, all of the stuff that Freedman has been saying in the press, primarily made by statements after December 21st. Further, some of the supplemental responses are incredibly vague in identifying the reporters, such as only including the initial for the last name of the reporter that appears to be well known to the Wayfarer parties. So they didn't even provide the full name of reporters, they just sort of said Brent M. There is no reason for any of the Wayfarer parties to leave it to the Reynolds and Lively parties to guess the full name of specific reporters of whom they were in direct communication. I don't know why they would think that that would be an appropriate response, because absolutely no, they have to provide the full names. Master Jinx says, kind of seems like they're not going to pursue interference with the contract. I don't know. I think the problem they have Monday is they have to provide the contracts. And I think we already know that the WME contract was likely a verbal contract, and Lively's contract likely protects her, which is why it was never part of the original complaint. I think, and I'm going way out here, I think that if the contracts really proved what they were saying, they would have included them in the initial complaint, or at least in the amended complaint. But they didn't, I think, was them trying to not disclose the contract as much as possible, to try and get through the motion to dismiss, at least with it. And now Lyman's saying, hey, you can amend and you can refile these complaints, but I need to see the contract to know whether I can toss this with prejudice, I think is really indicative of, I don't think they are going to succeed with an amended complaint, and they may just not bother. So we'll see. Sophia says, couldn't they just lie about this and not give whatever other information they have? They can, but there's a problem, right? A lot of this stuff is being asked, and we'll talk about it in a minute, is because Lively likely has information to know that it's relevant or know that they have done these things. You don't typically just ask somebody of like, hey, what email accounts did you use to provide for third parties? It's a very specific piece of information. It's a very specific tactic. There's probably a good reason why they believe that. And if the Wayfarer parties turn around and say, hey, we don't have any of that information, and they're not being truthful, they can go to the court and say, hey, we have this information. They didn't provide it. We know they have it. Here's our evidence. They're lying. And there are judgments that can happen to basically say, well, if they're not going to provide information, when we get to trial, we have to act like they did this because they're not going to provide the information. So it's damning for them. And I'm not sure why they would want to do that, but it looks like they've gone that way in a lot of the evidence. They're trying to provide as little evidence as possible, but in doing so, they are really pushing that they could end up with these judgments against them when it gets to trial, that could cut off a lot of their defense. especially of like, say, the smear campaign. Oh, we didn't do the smear campaign, all of this. Well, if you're not willing to provide those communications and show that, then the only reason the court is going to assume why you didn't turn over that evidence is because it's incriminating. And so moving for a judgment to say, hey, act as though they did do this because they're refusing to show evidence they didn't. All responses should be full and complete. Yeah. So in terms of the content creators, she says that none of the Wayfarer parties served any supplemental responses and didn't answer that question at all. So then Wayfarer come back and confirm, and they kind of bring up the problem of essentially the Ryan Reynolds problem, right? They did provide that tag, only one of Lively only asked this request of tag. Everybody else that was asked of it was to Ryan Reynolds interrogatory, and they say, look, he was dismissed, and we don't need to, right? He's no longer part of the lawsuit because our complaint got dismissed, so we don't need to respond to Ryan Reynolds's requests. In terms of the media outlets, again, they argue that they failed to respond, that Abel and Nathan failed to respond, but again, that interrogatory was only served by Reynolds. Look at me. See the junk file? Look at it. We've come so far. And then for the content creators, they've argued that you know, it's not relevant. We shouldn't really have to comply with this. Lively sought to compel only a response from tag, not from anybody else, and that, you know, we should only be going after witnesses with knowledge of information relevant to the subject matter, and those content creators aren't really relevant to all of this. So Lyman comes back and makes his decision. He basically argues that in terms of Reynolds, yeah, Wayfarer is right. The Reynolds is out of the motion, so he shouldn't get a response. So they're right about that. In terms of the email, what do we say? The motion to compel is denied in terms of the email. So Lyman's reasoning is, he says, look, the interrogatory, failed on that one. Interrogatory is sufficiently specific to enable a targeted response, right? And he says that, and where am I losing this? He's basically saying that their argument's complete. It's all in the footnote. The fact that Reynolds could be brought back into the amended complaint is no basis for them complying with his requests. He goes on to say, and this is where things get interesting, although Lively expresses dissatisfaction with the response, the court understands tag to have construed the word access to include access through login credentials by placing the information in a draft folder or other email repository and providing a party with viewing access by screen sharing or other means, and thus to have completely answered the question. So Lively's dispute was, she felt that Wayfarer was saying, oh, we didn't provide email access to anybody. And they were using access to just mean login credentials. And Lively was saying, oh, no, they're interpreting it to just mean login credentials. We mean something broader about access, and that's why they should be forced to compel. Lyman's coming back and saying, no. I take Wayfarer's response to be that broader understanding of access to include credentials, viewing access, screen sharing, or any other means. And that they have, by saying they didn't provide it to anybody, they've provided a full and complete answer. And then he says, to the extent that tag have answered the interrogatory falsely or inconsistent with that understanding, other remedies may be available. This is him tipping his hat to Lively and saying, hey, if your beef with this response is because you know they're not telling you the truth, you have other remedies for you, other motions that you can file to prove that out and go after them. So from what we were talking just before, Sophia, about, well, why couldn't they just lie about this? Lyman's actively tipping his hat here to Lively and saying, hey, if you think they're lying, right, and that's why you're upset with the answer, because you don't feel like it's consistent with what you know to be the truth, we can go for them. That should make Wayfarer very nervous. If if they're not telling the truth. I'm sure they have answered that question incredibly truthfully, and Lively is just frustrated that it wasn't the answer she was wanting. I'm sure that's the case. We will see. In terms of the reporters, Lyman comes back and says, no, you've provided no justification for withholding the responses of Nabin and April, and agreed to provide those responses. Regarding the period only up to December 21st and the present, Wayfarer parties object that although the amended complaint alleges the smear campaign is ongoing, it doesn't assert any claims. These objections do not provide a basis to deny the motion. Although the amended complaint does not assert claims, it asserts that attempts to discredit Mr. Reynolds were part of the campaign against Lively after December 21st. And although it cites specific statements by the defendant's lawyer, it also states the defendants themselves continue to be involved after December 21st. And so he basically says, we're granting that, but also the extended time frame. The Wayfarer party's engagement with media outlets after the release of the CRD complaint is relevant to the truth or falsity of these allegations, and the Wayfarer parties have not raised any other objections. So he says, nope, we're granting it, let's go, let's move on. In terms of the content creators, he again kind of says, well, it's propounded by by Lively to tag and Reynolds to remaining else. The Reynolds ones don't have to be complied with because, and then he says that the definition they've used of content creators to mean any individual who sees or influences social media content is not hopelessly vague, as Wayfarer allege, or is it burdensome? It does not include any person who can generate, create, or influence online content, but only the smaller subset of those who do on behalf of a given Wayfarer party, and as such, it is granted. So, in short, he argues that TAG have completely answered the question of whether they provided email access, and if they're lying about that, invites Lively to challenge it. In terms of reporters, he says they do have to comply and produce the list of names of reporters, and for that longer date up until the present, not just up to December. And in terms of content creators, then yes, TAG do have to produce the names of all the content creators that they have used to provide services indirectly or directly on behalf of Wayfarer. So probably some people, maybe some content creators who might be a little nervous out of that. I don't know. Maybe it's nobody. So moving on to now Lyman, Freedman, Tettleman, and Cooley. So as I mentioned, this kind of follows on from what we just talked about. Lively's alleging that Freedman's law firm themselves are involved in influencing media and content creators as well. What we see in this case is a stipulation, and it's the back and forth between both parties in one document, and this is filed over in California. He's filing a motion to quash Lively's subpoena, and so we see the arguments going back and forth between it. Freedman makes the usual arguments that this is basically Lively's backlashes that she's facing is all self-inflicted. Lively gives her introduction and makes the point of long before Freedman was ever the counsel for Wayfarer back in August, Melissa Nathan sent a message to Jennifer Abel saying, hey, we can start a thread signal thread with you, me, and Jed in case you need him to connect you to Bryan Freedman because they're very close. Lively's using this to point out that Freedman was involved and part of the smear campaign long before the litigation, before the CRD complaint, and before he was representing Wayfarer as their attorney. And as such, those communications that he was having outside of representing them in litigation would be fair game. Let's see. And that she also wants to transfer this over to the Southern District of New York, and pointing out that while Freedman is opposed to that, he doesn't actually provide any arguments as to why they shouldn't be allowed to transfer. Liner has no reasonable basis to claim that transfer would be burdensome, given that they're already doing all of this in New York. And again, bringing up that February hearing that we talked about, Freedman had said that I want to consolidate everything. It makes sense to have all one proceeding in front of one court would make the most sense. So they're using Freedman's words against him here from back then of why he had tried to consolidate everything in one court, now pointing out that, oh, now he's trying to do things in separate courts, We should honor Freedman's own words. I'm not going to go through all of the requests for production, but basically it's a very much similar of they want any content creator that they had been involved with, by talking about you, meaning Liner, Freedman, Tattleman, and Cooley, that they had, talked to any content creator and been involved with them. From July 1st through to the present. Let me see. Freedman's response here is to basically, am I on the right page here? Page 12. That they were providing litigation support in here. Requests on seeks agreements between the content creators through the present, a request documents from opposing counsel during litigation implicates these different privileges, of attorney-client privilege and all the rest of the stuff. Where did I see that word about support? Yeah, there it is. They want to provide content creators. They're saying it's vague, which is what they argued over in Southern District of New York, and then also that these sweeping definitions embrace, among other things, any person who posts on the internet, and vendors such as digital service vendors hired to provide litigation support. In what world are content creators providing support for your litigation? That seems very interesting. Confession to kind of make here. They go on to say, second, agreements between LLC and broadly content creators are not crucial to her claims of sexual harassment and emotional distress. No, but they are crucial to her claims of a smear campaign. And then say, third, the request targets potentially privileged information with content creators who may have been retained to advance the goals of the litigation. Again, how are content creators supporting the goals of your litigation if there isn't this smear campaign going on? I don't know what this argument is. They argue that in having to produce this, it would violate the attorney-client and work product privileges. Lively comes back to say, is it here? I guess not. Page 14, client before litigation. I guess not. All right, so Lively comes back and says, look, they're relevant because it's agreements between Liner and any content creator, whether those agreements exist and with whom is relevant to how the Wayfarer parties pursued the alleged retaliation campaign. And this is not merely hypothetical. Mr. Freedman's Rolodex of clients has included several influential figures who have been notably vocal, and the footnote calls out Megyn Kelly, who is a client of Bryan Freedman's, and Perez Hilton, also a client of Bryan Freedman's, who have spoken out and, taken to defending and pursuing, if you will, the goals of this litigation on Liner's behalf. So she says it's very relevant, their information that they might have. They argue it's pretty narrow, the request that they're arguing for, and then they say, Liner does not claim that this information is irrelevant to Lively action, only that it's not crucial to her sexual harassment and emotional distress claims. So saying they're intentionally narrowing it to just some of her claims. But in other words, again, a lot of like this legal litigation, your silence, right, is an admission. By Liner's own concession, the information is relevant to her other claims, including retaliation and conspiracy, and that is precisely the point. The information is crucial to Lively's ability to document the untraceable retaliation campaign against her by enabling her to propound discovery into the Wayfarer party's digital and media network, which Liner may have taken steps to conceal. There's substantial need to obtain it from Liner, as there's no other means to obtain this information. In the particular, to the extent that such agreements exist between Liner and content creators, they wouldn't be able to be found outside or apart from Liner themselves. And Liner didn't dispute this consideration. And Liner's involvement here isn't as litigation counsel in the pending litigation. Rather, given that Lively filed the complaint on December 20th, the work that Liner performed until that date was exclusively as a witness to the underlying events, not as to counsel. Likewise, any work that Liner performed in deploying or directly retaining content creators to further a retaliatory and anti-Lively narrative since that time would not be in furtherance of litigation strategy, but as an agent involved in the liable conduct. So she's saying, look, the attorney-client privilege doesn't work here because they were doing this stuff before they were retained as counsel in the action that they're talking about. Any of the work they did then couldn't have been part of litigation strategy because there was no litigation. Well, such information is not privileged or otherwise were protected, while Liner argues that Request 1 targets privileged information in the event that content creators were retained to advance the goals of litigation, which would itself be indicative of the retaliation campaign Lively alleges. But counsel agreements and engagements are not privileged. Let's see. In this scenario, attorney-client and common interest protections could not encompass the content creators as public relations professionals retained by Liner because they would lack any legal purpose and would not facilitate Liner's legal representation. Right? Their intent and their purpose was to do PR, not legal litigation, or to help with providing advice in terms in preparation for litigation. They were to just do PR. They argue it's not overbroad. Yeah, and I think that's mostly everything in here. So they go through again with more of these and they expand it to services rendered, payments, and much of the arguments between the two are very, very, very similar. Let me see, page 36. I just want to go down to that, or 35. Let me just go to page 35. Oh, it's not going for me. Yeah, it is. It was there. They were saying she wants documents and communications between you and any journalist, right? Not just content creators, but we're also going after them. Liner argues that it's so broad because it's any reporter. It is difficult to conceive of a broader, less particularized discovery requests than one sweeping in virtually the entire media. But again, it's only concerning or related to the consolidated action, Lively, Reynolds, the Wayfarer defendants, the digital campaign, or the film. It's not anybody ever that you've talked to. Lively's response is that Lively alleges that Freedman defamed her repeatedly while acting on behalf of the Wayfarer parties, and the extent to which Liner has communicated regarding Lively, whether in connection with planting of a false or misleading narrative or in connection with those defamatory assertions, is indisputably relevant to the defamation claims. Liner acknowledges that Lively's defamation claims are squarely at issue, so there can be no legitimate question that potential publications of the alleged defamatory statements are relevant. And although Liner claims that a smear campaign is not in and of itself actionable, that ignores that not only Miss Lively's specific defamation claims, but also her false light complaint, as well as her allegations that Freedman was a precipitant witness, fact witness to a retaliation campaign that began well before litigation in this matter. So, yeah, this is a big deal. You don't go after opposing counsel. It's a big deal to go after opposing counsel like this. I don't know if it will be granted entirely because it is not really seen as good sport to kind of do. But I do think Lively's got a good argument that Freedman was involved long before December, right? And the communications that Nathan and Abel show that he was involved and knew about what was going on. And the question has to be, to what extent was he involved? Who was he involved with? Who was he talking to? What was he doing? Given that he was not there as counsel at that point. So be interested to see whether this gets granted or whether this gets moved. I believe there is a hearing that's going to happen on this in July. I just don't remember what date. So I think it might be that one there, July 10th. We'll be interested. I don't know if there's going to be any more filings before that date or if it just goes straight to this hearing and they will hash it out in the hearing. All right, last motion to compel, and it's the big one. It is the motion to compel text messages from Taylor Swift. Before I get to it, I'm just going to catch up with chat a little bit. We're good, right? We got about 30-40 minutes to finish this up, and then we should be good for part 2. I will give you 10-15 minute break to grab water, bio break, and then we will do this all again. So pace yourselves, guys. Mossy Jinx says, Freeman even said Blake had contractual rights to her image and likeness, so she didn't sign a contract. So she did sign a contract. Yeah, and Lively kind of alludes to that in her response to her motion to dismiss, talking about Wayfarer didn't allege that she didn't have a right to edit the movie or have control or like have input on the promotional material entirely because it probably was in her contract to be able to do those things. If she didn't have a good contract, they would have said that she had no right or business being involved in those things. The fact they didn't make that argument strongly suggests she has a contract and she was allowed to do those things. Junior says, I believe she has a contract, but how she wanted it. Yeah, we will see what she's got. And but again, I don't think they'll file. I'm not going to keep repeating that because there's a huge possibility I am wrong tomorrow, and you are all welcome to jump in the comments if you are watching this after Monday and I was wrong, to go, you were wrong. I could very much be wrong. My lady says, I think it's funny. The most interesting part of Lyman's writing was when he was analyzing the New York Times article coverage of the smear campaign. It feels like he was like, finally something well written. I mean, it's interesting to me, again, that his point of, for you to make the claim of defamation, you have to knowingly think things are false. Any reasonable person seeing the information, seeing the text messages, reading the article would conclude it as true. Therefore, they weren't acting with actual malice. Gina Richards says, I think it's funny that Justin Baldoni's lawyer said there was no smear campaign. Yes, he also said there were no HR complaints. And then I think like 2 days later, the Hollywood Reporter article came out saying, oh yeah, we know about the second HR complaint from Jenny Slate, which had to have been leaked from Baldoni's side. But like, it's interesting to me that in the press, he says things like, I'm going to release every text message, and then all these motions to compel, and they're not producing anything. He says there's no HR complaints, and then we've got the messages of them behind the scenes talking about the HR complaints, which we will talk about in part 2. Yeah. All Scientist says, gotta go. I will catch the replay later. All right, appreciate you. Thank you so much for your support. I hope you have a great day. Look forward to when you come back and catch the replay. I think DU also has to go for work. All right, bye all. Have great days. You too. Hope work is good and goes quickly. Gina Richardson says, it is crazy that these people that are all against her or Bryan Freedman's are connected to them. It is just such a coincidence. Now, I will say, this came up this week over on Reddit because Perez Hilton is talking on Reddit, and Perez Hilton has categorically denied that Freedman has reached out to contact him to talk about this topic, to go after Blake Lively, or ask him to produce any of this content. Now, to be fair, that is a Reddit post. It is not a declaration under oath in court, but we will say he seems very adamant that he has not been encouraged by his lawyer to say anything. My lady says, I'm on your side. I think they won't file. All right, well, we will be wrong together. Continues, his tone is very matter-of-fact when going over the other claims, like checking off a list. But when he was analyzing the article, his tone seemed to shift, like really getting into it. I feel like that was him trying to be impartial, and I think that was the piece where he was like, now I'm revealing some of my parts. Caspian Kate says, I'm so far behind the ball, but I've got so much respect for y'all keeping this up to date. Hey, I mean, we are reviewing from 2 weeks ago, right? Like, we're reviewing here from July 13th. So we're all a little behind, but we're playing catch up, and by the end of tonight, we will be caught up. And Caspian, if you have any questions, feel free to ask. I'm sure chat will help catch you up or fill in any blanks. There are no dumb questions, and we are all piecing this together. We've all missed stuff, so feel free to ask. All right, and we will catch up. Miley says, it's okay, I've been losing sleep. You should protect your sleep. Yes, definitely protect yourselves. Definitely protect yourselves, especially right now. It is terrible outside. It is terrible. All right, so Taylor Swift. We're coming into this drama at this point. Bryan Freedman had alleged that he had uncovered a scheme of extortion, threats, and blackmail. And the reason he needed Taylor Swift's text messages was because Blake Lively had threatened to expose 10 years of private personal communications if Taylor Swift didn't issue a public statement in support of Blake Lively. Now, Taylor Swift never issued that public statement, but it didn't stop Bryan Freedman from saying that I had a phone call, a anonymous source had tipped me off to this, and so this is why I need Taylor Swift's communications. And he'd gone about subpoenaing Venable, her law firm, in order to obtain them. That subpoena was quashed. And in the response to it being quashed, Bryan Freedman took to the press saying, "We have got everything we need." Or rather, the Daily Mail published this, saying that an insider said that Bryan Freedman said this. Bryan Freedman also went on Megyn Kelly, I think last week, where Megyn Kelly was asking about Taylor Swift. And he was saying, I have to be careful about what I can say. I don't know if we're going to need additional evidence more than the evidence we already have to go after this. But importantly, what never happened, despite the fact that the subpoena was withdrawn and the motion to quash was withdrawn, Bryan Freedman never filed anything else about this. He has evidence, apparently, of extortion and blackmail, but nothing hit the docket. He has evidence that Blake Lively's lawyer was involved in this, but has filed nothing to get that lawyer kicked off the case or recuse himself or go after him or report him to the bar, which would be duty-bound to do. He would have an obligation to report him to the bar if he knew that he was conducting himself in an unethical manner and committing crime. So it's been strange that there was nothing said of this. And then we get this protective order request from Blake Lively. Saga is that Wayfarer are continuing to ask for communications between her and Taylor Swift, even though they had withdrawn their subpoena for those text messages. Good cause exists for this request because it has been the Wayfarers party's tactic since August to make Taylor Swift and her fanbase central to their media strategy against Lively, which they have documented in both the communications and the scenario planning document. The scenario planning document warned that Blake Lively has some of Taylor Swift's fanbase, and so they would need to be careful, and also wanted to talk about how Blake Lively bullies women in the same way that Taylor Swift has a reputation for being a bully, which, as I've covered before, is almost verbatim the accusation that came from Scooter Braun's wife about Taylor, calling her a bully. Miss Swift is not central to Miss Lively's claims, unlike other witnesses she's identified who the Wayfarer parties have ignored, and is otherwise irrelevant to the Wayfarer party's claims, which were dismissed on June the 9th. The Wayfarer party should not be permitted to withhold documents from Lively while demanding her communications with Miss Swift. Because of this and their continued focus on Miss Swift as a media strategy, not litigation strategy, Lively requests that she be relieved from producing documents responsive to requests numbered 108 and 109, asking for her communications with Taylor Swift, seeking all communications and documents relating to or reflecting Miss Lively's communication with Taylor Swift relating to the film or the action. They talk specifically about this, that Wayfarer party served a subpoena on the law firm Venable, and that served as outside counsel for Swift for their communications between Swift's lawyer and Lively's counsel. The Wayfarer parties subsequently served a Rule 45 deposition and document subpoena on Swift that sought documents, and then withdrew them. After nearly 2 full weeks of tabloid coverage on the subpoenas, as well as the now stricken filing about the extortion and blackmail, the Wayfarer parties then withdrew both subpoenas on May 22nd, the same day. An exclusive article in the Daily Mail, co-authored by James Vituska, who we talked about earlier, and as Lively points out, the relationship with the Wayfarer parties is already part of the record. It's quoted an insider stating the reason they dropped the subpoena was they got exactly what they were seeking. Sending a subpoena to Taylor and Taylor's response has provided Baldoni's team with everything they need. The insider continued, everyone is extremely pleased with the end results and the information it yielded. They got exactly what they were hoping for. She talks here about the 50-minute interview he did with Megyn Kelly, where Freedman again says they may not need evidence related to Taylor Swift in addition to what he already has. Lively then emailed Wayfarer parties about their public statements, interpreted to mean that the intent interpret to mean that either the intent of the Wayfarer party subpoena, since our understanding is they obtained no discoverable information as part of this process, was to induce a scandalous allegation against Lively and her counsel into the public domain to generate stories, or the Wayfarer parties did receive material to their subpoena, which would come as a surprise because no materials have been provided to us. So Lively includes an email chain where, as a result of basically Wayfarer withdrawing their subpoena and crowing to the press about having everything they needed, saying, cool, great, you got a bunch of material from Taylor Swift. We want all of the communication that you obtained from that third party, please, thank you. they never responded. And so they took the response to say, hey, to date, you've made 3 small productions, none of which includes any materials that you received from third parties, including in connection with the decision to withdraw Venable and Swift. We can only conclude that no such materials exist, and the purpose of subpoenaing Venable and Swift was not to procure any relevant discovery, but rather to generate a public relations stunt. They also included an email from from Taylor Swift's counsel, Venable, who states that, hey, we're letting you guys know that the Venable subpoena and Taylor Swift subpoena have been withdrawn by Wayfarer. No documents were produced and no deposition is being scheduled. Accordingly, we'll be notifying the court that our motion to quash is moot. So we have Taylor Swift's legal representative saying that they never handed over any information. We have Lively saying, cool, if Wayfarer got information, please, you are required to hand it over to us, and they've never handed anything over to us, so that must mean they don't have anything. Therefore, we want a protective order, because it's very clear that Wayfarer are using this whole situation only to generate PR. There's only 2 options here. Either Wayfarer already got all of the text messages they need, which is what they said, and then therefore they don't need the information from Blake Lively. Or they don't have the information that they needed, it was all a PR stunt, and they're only requesting that information from Lively because it's a PR stunt. And so therefore she shouldn't be ordered to comply with their request. So Wayfarer come back and respond and say, well, the reason is that Lively, she should still have to provide her conversations with Taylor Swift, because Taylor was mentioned in Lively's initial disclosures. Initial disclosures are a list of people that you think are worth talking to, that the other side should know about, that are potential witnesses, fact witnesses, or people who have relevant information about whatever legal proceedings that are going on. They then go on to say, well, Lively identified certain individuals who she believes have discoverable information. According to Miss Lively, we don't know. It's all redacted. So we don't know what, according to Miss Lively. But apparently, according to her, blank. Therefore, we should get her text messages between Taylor Swift. Goes on to say, thus, Miss Lively admits that blank. So we don't know what they're talking about here, but it's very clear that what they're alleging is that Lively had, in her initial disclosures, named Taylor Swift as a witness or somebody with relevant information. And so her text messages between them are fair game, which, to be fair, is a fair argument. But they go on to say, well, the reason we need them, the reason we need Taylor Swift's text messages is because they're relevant to the garden variety emotional distress. Now, remember, we talked earlier about her intentional infliction of emotional distress was kicked out of the court, but she's still be able to claim for damages on garden variety emotional distress. Well, they say, well, those communications are key to us being able to defend against those claims. If Miss Lively and Miss Swift socialized after the alleged incidents at issue, as has been reported, and they cite a People article about Travis Kelce doing a double date with Blake Lively and Ryan Reynolds and Taylor Swift, then that would open them up to have relevant communications to disprove her purported emotional distress, because clearly they went on a double date, and therefore she probably said, hey, I wasn't sexually harassed. I don't know how that's relevant, but there we go. The Wayfarer parties then call out her use of the Daily Mail article and, talking about what a insider had said, saying that that's just hearsay. It's nothing to do with us. We never said that. The Daily Mail are just saying some insider said it. That's not us. And then go on to say that, look, in any event, as both Lively herself claims and Miss Swift's legal counsel claim, no communications between Lively and Miss Swift have been provided to the Wayfarer parties. They openly admit that that news story about where they had said that they had got relevant information from Taylor Swift was a lie, that the Wayfarer parties don't have anything. So having put out this whole subpoena for extortion, the whole extortion claim has now disappeared. At no point in this do Wayfarer say that they need those text messages between her and Taylor Swift to prove out the extortion. They're falling back to garden variety emotional distress. The extortion claim apparently has disappeared. They argue that she should also be compelled to a number of other requests that they have that she has not committed to. As part of this, Wayfarer also bring out their initial disclosures. Now, Lively's initial disclosures are included as an exhibit, but they are sealed. Wayfarer's are not. And as part of that, they show a bunch of people that Wayfarer say, hey, are important and worth talking about and have information about the case. Part of those are Shekinah Reese, which, if you'll remember way back at the beginning of all of this, Shekinah Reese was the assistant to Mr. Heath that Lively's trying to compel as part of the Wayfarer third parties, who is not producing documentation. They're not the only person of the Wayfarer third parties named in here. Ashmi Elizabeth Deng, that we talked about, the VP of Marketing and Comms, is also named by Wayfarer as somebody to talk to who has important information. Mitz Toskovich, again, also named by Wayfarer as somebody who has relevant information. Who else we got? Tara Hanks, president of Wayfarer, also named by Wayfarer as somebody that that Lively should talk to. And then over on page 10, we have, oh, I guess I got the page wrong. I got the page wrong. Is it 9? Yeah, it's page 9. AJ Marbury and Dion Suleiman, who, if you remember, were the assistants to Mr. Baldoni. So it's really interesting that the people that Wayfarer themselves say have relevant information for this case, who will help to prove out their defense, are the people that Lively has asked for information who are not giving that information, are refusing to comply with handing over documentation. You would think that if Wayfarer were as innocent as they claim and have all this information about Lively and how all of this is made up, they would be wanting these people to talk. They would be wanting to hand over reams of evidence. Look at all of this. These are the assistants to Mr. Baldoni and Heath. They would have all their conversations. They would know all of the information. But they're not handing over that information. I wonder why that would be. Why would the people who were on set with Baldoni, who have information about all of the events that happened as they occurred, not be handing over information, despite the fact that Wayfarers say that these are the people to talk to? Interesting. Interesting indeed. So Lively comes back, asks to file a letter to basically say, well, Lively did amend her initial disclosures, but she did so afterwards. They say here, Lively, to be clear, Lively supplemented her initial disclosures to include Ms. Swift after the public representations that the Wayfarer parties got exactly what they were seeking and were provided with everything they needed. Because they were suggesting, therefore, that Wayfarer parties were going to be handing over information within the case connected to Taylor Swift. They argue that this bait and switch can't provide a basis for the Wayfarer parties to obtain discovery on what the Wayfarer parties supposedly already had, right? Feels unfair for them to say, hey, we've got information from Taylor Swift, and Lively's team says, okay, Taylor Swift is a person of interest, and then Wayfarer turn around and say, okay, well, we want those messages because now you've said that Taylor Swift is a person of interest. It's all very mixed up. Unfortunately, we go on to say then, where are we? Page 13? Oh my goodness, we're away from this. She also goes on to say that, where are we? This idea that, their focus is on the emotional distress claims is a post hoc rationalization, which of course the requests existed before she dismissed her intentional infliction of emotional distress claims and was going after garden variety emotional distress. So them backing you now and saying that that was why doesn't fit with the timeline. It's a post hoc rationalization. They're making it up after the fact. But the interesting part is, as we go down to page 13 and we get to the email discussion that they have, Lively's team point out that they have produced 2,832 documents. And remember, Lively is a single party in this complaint, whereas the Wayfarer parties, who are collectively 10 different entities, have produced only 754 documents. I'll get to that in a moment. The final part to get to is, unfortunately, that the judge's decision came out and the judge basically said, no. The decision is that these text messages are relevant, and that just because they made these public statements that they claim that they already had the communications, it doesn't matter. Where are we? limited. However, yeah. He argues it's not too broad because, look, although you did identify them in the initial disclosures, it doesn't necessarily mean that they should hand over communications. He does say, look, the communications that we're asking for Swift are limited to just about the film or this action. They're not all of your text messages. They're only text messages where you're talking about either the movie or about the lawsuit afterwards. Judge argues that Lively alleges that Baldoni and Heath harassed her in numerous ways, that her concerns about their behavior began early in pre-production and production process, that she expressed those in contemporaneous messages, and that Lively had represented that Swift had knowledge of those complaints or discussions about the working environment. The requests for the messages with Swift regarding this film and this action are reasonably tailored to discover information that would prove or disprove Lively's retaliation and harassment complaints. So he then also kind of talks a bit about all of this going on with Wayfarer, to basically say, look, just the fact that the Wayfarer parties have dramatized the request in the press doesn't justify a protective order against the production of responsive documents. Lively's motion for protective order is denied. And all of that feels terribly unfair. This was all done to generate headlines like this, right? That Lively blackmailed, that Lively extorted Taylor Swift. And we have now seen by Wayfarer's own admission, they never got any information about it. They're not even seeking information about extortion or blackmail anymore. So clearly that was all BS. It was all made up. Freedman just made up that argument and has now, a few weeks later, abandoned it entirely. So it's frustrating that this is essentially being rewarded, that those text messages will be turned over. And I think it is a little naive to think that they will not be misused. Lyman's decision there also quotes the fact that there is the protective order in order to be able to protect those text messages from being leaked to the press. We will see if that ends up happening. I think we're all pretty much expecting that those text messages will be released in some form or another to the press. But to go back to Lively's email, talking about the volume of production, I posted about this. Did I not download them? Did I not download the text messages? I didn't. Okay. One moment. Maybe I put them in the other one. Yeah, I did. So I wanted to talk about the volume of production, right? Because, again, it is important to note that Lively is one party, Wayfarer are 10. When we talked about this case originally, Baldoni and Freedman were talking about they were going to release every single text message and that they had nothing to hide. The evidence was on their side. They were going to show everything. They were going to put up a website. They did put up a website that they put their complaint and their Exhibit A timeline up on because they were so sure that all of the evidence would prove it out. Yet what we're seeing as this court progresses is that Wayfarer are not providing evidence. Blake Lively, a single individual, has produced many times more documents than Wayfarer, who are 10 people. Somebody on Twitter responded to me and said, well, it's not about the amount, it's about the quality. Maybe it's just she's overwhelming them with irrelevant stuff. There's 10 people on the Wayfarer side, which means when you break it down per person, or per party, I should say, because some of those are corporate entities, it is less than 80 documents apiece. We're talking about a time period of a year and a half that we're producing evidence for. And we're saying that every single person on the Wayfarer side, the companies, the movie, Wayfarer themselves, would only have 80 documents from a 18-month period that are relevant to this case. Meanwhile, Blake Lively has almost 3,000 that she's produced. It is inconceivable to me that you think that this is acceptable or that you think that this is consistent with a party showing all of their evidence. This is very clearly one side trying to suppress as much evidence as possible, trying not to reveal as much as possible. Now, ultimately, it will damage them if it does go to trial because they will not be able to use any additional evidence in their defense. You don't get to just produce evidence on the day. The information that they don't provide to Blake Lively cannot be used to defend themselves. That already creates this conclusion that they don't have a lot to defend themselves with. Even if they're telling the truth, even if they are saying that they have all of this evidence, what they're showing is they don't have a lot of evidence with which to defend themselves. That doesn't bode well for going to trial. You don't want to go to trial with just a handful of documents with which you can use to defend that you're telling the truth. The reality, like I say, is more likely that they are deliberately holding back information as much as possible because they know that it doesn't prove that they're telling the truth and that every document they hand over is a further nail in their coffin. But we'll see. All right, we are bang on time. So congratulations to chat. Congratulations to me for nailing us, completing part 1 on time. We're going to be back in about 30 minutes for part 2. We're going to talk about tag. We're going to talk about Jed Wallace because the Wayfarer parties and what they have handed over has kind of revealed more of the smear campaign and unfortunately possibly shown some contradictions in their story. So I will just wrap up by quickly reading through the last of chats. My lady says, I thought it was interesting that Lyman said it was rare to strike those things from the docket, but he tossed that immediately. Yep. I'm going to say, I don't think people like bullies in general, but the bully label is also very gendered. It is as well, but I mean, it's also just women get called out more for being aggressive in a way that men are celebrated for it. I believe Taylor Swift has a song on that very, musing on that very concept. Sophia says the extortion and blackmail is such a joke. He has nothing. Yeah, I mean, riddle me this. If the extortion and blackmail was real, he's admitted through this filing that they didn't get any information or evidence of it. Nobody handed over any information to them, right? He said that he didn't have any information from Taylor Swift, not just from her or her lawyers, any information, any communications between Lively and Swift at all, which means that even the rumor about Taylor Swift's dad, Scott Swift, handing over stuff was also false. And if you knew about extortion and blackmail, you would think you would be wanting to pursue that. But they're not. They're pursuing garden variety emotional distress. That's their big driver for getting those text messages. It shows that it was all a lie. And I think it's frustrating that there are no consequences for that. Miley said, I agree it feels unfair. I'm starting trying to understand justify, but I also don't want to put blind faith into Lyman and become what some Baldoni people are like with Freedman. I think, look, it shows that Lyman is going above and beyond to be fair. When the motion to dismiss came out, I think a lot of the Baldoni team were like, oh my gosh, Lyman is so biased and supporting Blake. And these are the decisions that unfortunately feel the same way to those who support Lively. They are unfortunately just Lyman going down the line and trying to be fair as much as that may not feel like justice. Lyman is human and can make mistakes. Yeah, and has been very generous to Wayfarer. I believe so. I believe he's been incredibly generous to them. Far more than I would be in this situation, not just because of like the Justin Baldoni and Wayfarer thing, but I think if I was in law, I would have zero time for messing around in games like this. I would be totally done. All right. Jugfarm says, it makes me mad he won't get disbarred for that. Yes, and I mean, like we've talked, there's so many shenanigans that Bryan Freedman has been involved in over the years. How he still has a law license, I do not know, right? There's been numerous complaints and judgments and calls for judgments against him for unethical behavior. I think like 2 or 3 that I'd seen. It's crazy. I don't know. I don't know what it takes, right? So we'll see. All right, guys, I will see you, like I say, in just under about 30 minutes. Go get yourselves a drink. Go get yourselves a break. Possibly a little snacky and a blanket too, and we will do this all over again. When we come back, we will talk about tag. We will talk about Jed Wallace. We'll talk about the smear campaign and anything else you've got. In the meantime, appreciate you. Thanks for checking out and staying with us tonight. If you like what we do, as always, comment, like, share it with other people. Let them also see the information. And yeah, I appreciate your support, chat. Thanks for hanging out with me. I look forward to hanging out with you again in like really short space of time. All right, guys, I will see you shortly.